Public Defender Chelsea Vergils with and on behalf of Cyrano Johnson. Mr. Johnson, please state your name.
Cyrano Johnson.
I mispronounce your name every time, sir.
It's okay.
I apologize.
Thank you, Your Honor. Today is the time and date set for a probable cause conference. Regarding that, we are asking for an adjournment.
There he is, Cyrano Johnson, standing quietly, but the silence isn't calm. It's loaded. This is no ordinary bond hearing. What unfolds next is a masterclass in courtroom tension, a moment where a small lie about alcohol spirals into a full-blown credibility collapse. Johnson claims he drank Odal-S, non-alcoholic beer. Seems harmless, right? But hold up, the judge isn't buying it. And the truth, it crashes in hard. Today's video follows the unraveling of a man caught between pressure, pride, and the cold, sharp edge of legal consequence. His lawyer tries to protect him. The prosecution raises serious red flags. And the judge, she's had enough. Stay tuned, because you're about to witness how one bad decision and one worse excuse can flip a courtroom upside down. And here's a question to kick us off. Would you trust someone who only tells the full truth when they get caught?
Does your client wish to stick to that story, or does he wish to tell me the truth?
I believe that he would not be sticking to that story, that he would be stating that he consumed beer.
That's correct, Your Honor.
And just like that, the story changes. First it was Odal's, now it's I, drank beer. This isn't just a contradiction, it's a red flag. Why lie about something the court is going to test anyway? This kind of moment is what judges call a credibility fracture. It's not just about drinking, it's about how far you're willing to stretch the truth. And look how calm the judge is, but beneath that, she's furious. When she asks, then why'd you tell everybody? Odal-S, she's not looking for an explanation, she's setting a trap. Legal note, any bond condition, especially one about substance use, is legally binding. Lying about a violation is often seen as worse than the violation itself. So what do you think? Was he just scared or trying to game the system?
I consume alcohol.
I know that. You lied to them. Did you even have an O'Doul's that day?
Yes,
How many?
6.
And then how many beers?
2.
So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too, because
Right.
you're violating your bond condition.
Indeed.
So, first of all, we did the calculation because the only story you gave is that you had O'Doul's. To get to the level that you were at, you would have had to have 25 O'Doul's in an hour.
Boom, the math doesn't lie, but Johnson sure did. This is a brutal moment. The judge walks him through a hypothetical. To get that alcohol level from Odal-S, you'd need 25 in an hour and no bathroom breaks. That's not just sarcasm, it's a courtroom strategy called discredit through absurdity. Judges use this when they want to show the lie was so dumb, it's borderline insulting. And when she follows up with, that's how stupid your story was, you know forgiveness is slipping away fast. This is the kind of moment that turns a warning into jail time. Let's be real, do you think he thought this through, or was he just hoping to talk his way out?
Counsel, what did you want me to do with this case?
Regarding the probable cause conference, we're asking for a 2-week adjournment so that he can show that he's going to comply with the court's orders.
Well, I don't think he's going to have a choice on that, quite frankly, Mr. Allen.
We are asking for him to remain out of custody today. This would be his first bond violation. He is here to be honest with you, although the truth doesn't always make sense.
Really?
He is.
Really?
He's here.
No, he was not being honest. I asked him the question and then asked him the question of why didn't he tell them? And he couldn't even be honest about that. I'll let you go ahead with your argument, but I'm not buying any of that.
The defense tries to spin a softer narrative that Johnson's trying to be honest, that he's under pressure, that he does volunteer work, but the judge isn't having it. Why? Because honesty isn't something you deliver after you're caught. This is a classic legal standoff. The public defender is playing the redemption and responsibility card, while the judge is laser-focused on personal accountability. It's a reminder that in court, your story isn't just about what happened, it's about when and how you choose to tell the truth. What would you do in the judge's seat here? Accept the explanation or call it out like she did.
With a scram tether, again, this would be his first violation. And he is asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have concern about Mr. Johnson's ability to comply with the bond conditions. As stated, this is his second offense. His and this scandal, I think it's just a couple of years. We would note that in this case, he allegedly was found not awake in a vehicle that was in the street with 2 guns on him, although he's only charged with 1 CCW.
And here it is, the twist no one saw coming. Not only is Johnson being charged with bond violation, turns out, during his arrest, he was allegedly found passed out in the street with 2 guns. Let that sink in. This isn't just about alcohol anymore. The stakes just went through the roof. Even if he's only being charged with 1 count of carrying a concealed weapon, the presence of firearms plus substance use is a combination courts do not ignore. Suddenly, the judge's frustration makes total sense because now we're looking at a potential public safety risk, not just a technical violation. What's your take? Should his bond be revoked based on this new info, or does everyone deserve a second shot?
In this matter?
And there it is. The gavel doesn't need to fall when the words hit this hard. Defendant's bond is revoked. Simple, final, brutal. Despite all the excuses, justifications, and emotional appeals, the court is making one thing clear. Truth matters more than talk. It's not about whether Johnson wants help, it's about whether he's ready to earn the court's trust. And in this moment, that answer is no. This decision is the system saying, we gave you freedom, you gave us fiction.
Of what he's pleading to. Who did this? Mr. Childers? Mr. Childers, type. Childers, you know what? No.
Okay, let's take a quick breath from the tension because now we're stepping into what I like to call team typo theater. The judge notices that a plea form is incomplete. The maximum penalty isn't listed. And what follows? A classic court moment. Everyone scrambles to cover for each other in the most awkwardly funny way possible. It was a group effort, but I'll take the blame. Well, she typed most of it. I just couldn't write that part. This isn't incompetence. It's just human. And honestly, it gives the audience a rare peek at how even in serious rooms, people fumble. What's your take? Sloppy error or harmless mix-up?
Well, she had did it.
I did, yeah, and so we will.
I wasn't going to put a max penalty for my client.
What?
It felt wrong to like do that part. So I was like,
That hurt. I just couldn't write that. I couldn't type that part. What is the maximum penalty on the one that, pardon?
1 year.
1 year, 2,000. It was a group effort. I like how they all
that
sat
again.
there and tried to protect each other. All right. May I have him sworn?
Solemnly swear in the affirmative testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Devon Haywood.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of use of a controlled substance. That's a misdemeanor, punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that, sir?
I do, Your Honor.
Do you understand what a no contest plea is?
Yes, I do, Your Honor.
All right, 2 things about it. I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
I do.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
I understand.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
I do.
All right. Basis for the no contest plea?
civil liability, Your Honor.
All right. And sir, to this charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct, sir?
Yes, sir, Your Honor.
You have any question regarding any of those rights?
No, sir, Your Honor.
All right. Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am. I'm on probation for
Explain the case.
Well, were you on probation at the time of this offense?
No, Your Honor.
All right.
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
All right. The court has been provided Washington County Sheriff's Office report, and I've also reviewed that report for their case number 24-42704. Any objection to the court having reviewed that report?
Okay.
None from us, Your Honor.
All right. Sir, you also understand that if between the time I accept your plea, if I accept your plea, and the time of sentencing, if you commit misconduct as defined by the court rule, two things would occur. You would not be entitled to set aside your plea, and the court would not be bound by any sentence agreement and or evaluation of your case. You understand that, sir?
I do.
All right. Based upon the review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt. Before I accept his plea, is counsel aware of any other promises, threats, or other inducements which have caused this plea?
Not available.
None, Your Honor.
All right. Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
August 14th, 2025 at 10 a.m. in Judge Washington.
August 14th, 2025. What time?
10 a.m.
10 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
So, what did we just witness? 2 defendants. 2 very different tones. One caught lying and had his bond revoked. The other admitted guilt, entered a no contest plea, and stayed composed throughout. This courtroom didn't just hand out justice. It handed out lessons. Honesty delayed is still dishonesty. And in front of a judge, your words have weight, but only if they match your actions. Sereno Johnson walked in, hoping to negotiate leniency. He left with revoked bond. Devin Haywood walked in with transparency and walked out with a court date and a plan. Justice isn't just about what's fair, it's about what's true. If you found this case as shocking as we did, make sure to hit that like button. Drop your thoughts in the comments and subscribe for more jaw-dropping courtroom breakdowns, because this is where justice meets real life.